Hi, everyone. Thank you for joining today's webinar presentation, Drafting Tips and Techniques to Get and Keep a U.S. Patent. I'm Allie Morton, the Product Marketing Manager at LexisNexis IP, and I want to cover a few things before we get started. During the presentation, please feel free to submit questions in the question feature in the toolbar. You can access the files pertaining to today's webinar in the handout section of that same toolbar. Also, a link to the recording of today's presentation will be emailed out to everybody in the next day or so. This is a very popular topic for us around drafting patents and drafting quality patents. So we have recorded a few previous webinars on similar topics, and the links to those recordings are included in the PDF of the slides that you can find in the handout section. Now I would like to introduce today's presenters. We have Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean was recently named one of the world's leading IP strategists by IAM magazine. Also joining us is Kristen Murphy. Kristen is a partner at Honigman and has a wide range of experience in domestic and foreign patent prosecution, including strategic patent portfolio development and management. Her practice also focuses on patent opinions, intellectual property valuations, due diligence, analyzing potential infringement, validity issues, and drafting and negotiating agreements relating to technology and intellectual property. Also joining us is Dave Spitzel, and Dave is an IP solutions consultant with LexisNexis IP. Prior to this role, Dave obtained extensive experience as a patent attorney with various IP law firms and as a chemical and biotechnology patent examiner with the USPTO. Dave is a registered to practice before the USPTO and is a member of the North Carolina and Pennsylvania bars. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Jean.
Great, thanks a lot, Allie. I really appreciate you all being here, and thank you for that introduction, Allie. We have a lot to talk about today, and I have a lot to say today. I'm going to be quite a active participant in the webinar today, and I'm really glad to have Kristen Murphy with us today. Kristen and I, we went to law school. I won't tell you how long ago that is, but we went to law school together, and so I'm always glad to have one of my law school mates join me for one of these webinars. And Kristen, I was looking at your resume. It looks like you've done just about everything from patent litigation to prosecution to licensing to strategic advising. It looks like you're practically on the short track to becoming a chief IP counsel at, although I probably shouldn't say that, Honigman won't let me have you do a webinar again, but I mean, you've really seen it all from a lot of different angles. And what I'd like to do is ask you to start us off here in a very basic way. I'll throw a very, quick question to you, and Dave, I'd like to get your thoughts on this as well. Topic of drafting has changed dramatically over the last decade for sure, but what is it that you think people need to keep in mind as we approach this topic today? And I know today we're going to talk about drafting mostly with respect to the computer arts, because that's where so much agita is at the moment. But what are the key things for folks to be thinking about?
Well, I would say, one of the first things that we have to keep in mind is, well, we work in the patent field and we look at patents all day long and communicate with examiners who also look at patents. These documents are not really drafted for those people. They're really drafted for the ultimate fact decider on whether or not something is infringed. And part of what I think that feeds into the 101 and really the 112 guidance that came out is, I like to call it show your work type of thing. When we were all in elementary school and we had some mathematical problem and you couldn't just put the answer, they always wanted to show your work. And looking at some of the changes that have come about in patent law in recent times, I think we go back to that core principle of show your work in the specification so we understand what it is you're trying to claim and that it's appropriate subject matter to claim, and it's focused, and we can, and somebody reading the patent can understand exactly what your metes and bounds are.
Yeah, I mean, because that's the name of the game, really. And sometimes it's unfortunately not all that easy. Sadly, a lot of times when these, not a lot of times in the software area, it's all the time, it seems. When these things are drafted, they're drafted for one set of rules, and then by the time they get litigated or challenged, there's a completely different set of rules. And that has been the source of enormous problems. And Dave, I know you're a former examiner, and as we're getting ready to take the stage here, so to speak, in the ready room, you were saying that, thankfully you did not have to deal with a lot of these 101 issues when you were an examiner. And, we laugh about that, right? Because back in the day, if we were told that we were going to be talking about 101 issues, people would have looked at us like we were crazy. But what do you think people need to know and appreciate? Because the law that it seems to me in the application that gets filed today has to be one that not only gets through the examiner, but it's got to be one that you have some confidence is going to stand the test of time.
Well, that's right, Gene. And obviously, examiners are human just like the rest of us. And when it comes to drafting application, even if you're a seasoned veteran at drafting applications, just due to the time constraints and whatnot, it's easy to have an oversight, a drafting oversight. And our tool, like Patent Optimizer, for example, will enable a patent practitioner to, quickly identify those drafting errors. And it could be something simple, maybe a claim objection, something you would get a claim objection to, like improper dependencies, missing claims, numbering errors, missing periods. But when getting into more substantive issues like 112, which Kristen had referenced earlier, we're helping the attorney identify 112 related claim issues. So whether it be during prosecution or post-grant challenges. And my point being is that if there's a drafting oversight and the examiners misses it as well, they're under severe time constraints, just as the patent attorneys are. Now you may have a patent that may not be worth the paper it's written on. So we're going to help you, identify claim elements that might be construed as being vague and indefinite, functional, impacting claim breadth and scope, and so on and so forth. So there is a tool that can drastically improve your efficiency, and I think that's really important, especially when you're looking at, the way things are going nowadays, where a lot of attorneys are not billing by the hour, but they're billing on a flat rate based billing arrangement. And so the quicker they can move on to the next billing opportunity, the better, without taking a hit to quality. And that's what Patent Optimizer is designed to do.
So now
Appreciate
the
that.
one thing that comes up there is, the idea that the fact that you can get it by the examiner is not really the standard, and it really can't
That's
be the
right.
standard, unfortunately, because examiners have a limited amount of time. Can you give us an idea? I think we all probably have some idea, Dave, but what kind of limited amount of time when you were an examiner were we talking about in order to deal with the entire case?
Well, it all depends on what your GS level is, and I know that, for example, new examiners just coming out of the academy may have a significant more time than, say, for example, a primary examiner. And so, it's been quite some time ago. I'm sure that the amount of time has changed, but it could be, maybe 6 hours, and that's it sounds like a lot of time, but it's really not, because what you're
It's not.
not only doing, yeah, you're looking in the prior art that's growing exponentially year after year, not just patent literature, but also non-patent literature. And when you're examining a technology where a lot of the terminology is fairly common, but maybe it's a unique synergistic blend or something like that. Now you're looking through a ton of references, and you're looking at cellulose, which is in all kinds of chemical compositions. So, trying to find that needle in the haystack is tough. And, hoping that you'll have some time to go back and put your, 112 hat on and look to see, if there might be some issues under 112 or even 101 for that matter. So it's really a lot on their plate. Plus they have to go back to their primary SPE and have them review it and then make changes. So it's not a whole lot of time. And I think back in the day there was some joking going on about examiners had a lot of time, and maybe back when they were in Crystal City, but that's certainly not the case nowadays. I think that they're very limited on time and they're trying to do their absolute best. And at the end of the day, we're all human. We all make mistakes. And the same goes on the patent practitioner side too. I mean, a lot of these 112 related errors are things that they could have avoided, but they failed to do so. So that it kind of cuts both ways.
Yeah, and usually what I say, now there's been changes over the years with respect to the examiner work production, but like if it's a kitchen gadget, maybe the examiner all in from start to finish is going to get 10 to 12 hours, maybe tops. If it's something that NASA is going to send out to orbit Pluto and all the systems there, they're maybe going to get 30 to 35 hours, and it's not a lot of time to read the application, read the claims, read the prior art, do the search, office action, interview, work with, your SPs, all those kinds of things. So the standard, I think, can't be, did you get it past the examiner? We have to, particularly in this space, go for a higher standard. So the topics that we're going to discuss today are going to be, we're going to look at best practices to deal with Alice, best practices for complete specification, and then best practices for dealing with Berkheimer or leveraging Berkheimer. And a lot of these things are going to weave in and out. We have slides for each of them, but I look at this myself as sort of like a holistic approach to drafting an application. So let's just jump in. And I guess the place to start here, Kristen, is in Alice land and in Wonderland, is to recognize that we're living in a world where an electric vehicle charging station, an MRI, and a garage door opener are all abstract. And and it's more than that, I suppose, right? Because it's about were they described properly, right? But this is the new world we live in.
Yeah, no, I agree, and I think one of the things in going back through, I think when we realized initially that we had the opportunity to protect certain software applications and improvements to computing technology via the patent system, where we didn't really think how we were going to go forth with that, practitioners tended to focus on describing the result that they were achieving. So, we want to achieve the result of an electric vehicle charging station, that it will charge the car. But, and it kind of goes to your point that you made earlier, there might be several different ways in which you can accomplish that. And perhaps the specification just isn't clear on how you're doing it. You've certainly got all the pieces there, but you're missing the key ingredient, and that's the how.
Yeah, right. And so, and when you're talking about the result, and this comes obviously from State Street. Now, I think State Street was correctly decided. I think it's unfortunate, however, and when I teach new associates and law students and patent agents how to draft applications, I tell them you need to operate with the presumption that State Street was correct, but with one big caveat. The problem that Judge Rich had with the test was it was useful, concrete, and tangible result. If you focus on the result, and that becomes the easy part to focus on, and that allows people who don't really understand computer technology to think that they can write a claim or application in this space, because everybody can write a recipe claim. Everybody can write a method claim. So everybody did. And there was no technology behind it. And it also turns your software into a black box. And it can't be a black box. If you want a black box, go get a trade secret. Keep a trade secret. And then the use is kind of a misnomer, because we have that's already accounted for in 101. But the concrete and tangible part, that's where the description, if you have an innovation, I think you need start with the presumption that it can be protected. If you really understand what it does, if you really understand how it does it, and then you can translate that into pen and paper, or now into text on a computer and file it with the office. So that's where we're going to begin. And here's the ubiquitous Alice slide, which we probably don't need to spend a lot of time on, but I always like to include for those who are new here. You start with the statute, but the statute's not enough because we have to then ask, is it directed to a law of nature? That's 2A. And then 2B, does it add significantly more? And at various stages, it can be patent eligible and or not. And then we jump into the January 2019 guidance, which is still the current guidance that the office and examiners are supposed to follow. And this is where we get into the two-prong inquiry. And this is under 2A. And this is important because I think, and Kristen, I'd like to get your take on this too, is, well, just your take in general. This seems to me to take us a lot closer to the European standard, the technical solution, technical problem standard. Does the claim recite a judicial exception? And if yes, does it incorporate that into a practical application? Well, the practical application, that really seems like a solution to me.
Yeah, no, I do think if people did follow the kind of European style of problem solution in the specification, that a lot of their initial rejections under 101 would probably go away. But, the flip side is that we're always reluctant to say anything more than we absolutely have to in a specification, because it could come and bite you in litigation,
Right.
especially what you're trying to do, you know, 10 years from the time you prepared this application. As you mentioned, technology advances. There are still core aspects of earlier patents that are vital and key to sparking the innovation, that maybe it's applied in a slightly different way, but the claims still are broad enough to read on that. It's just making sure you have enough, I guess, enough description of something that's akin to what you're trying to accomplish in the specification that you can point to later, because that'll be the challenge. It actually will be probably more focused on an enablement challenge at that point than a 101. If you've described enough to get it past the patent office, then you're like, well, did I describe enough to not read it on something completely different?
So let me ask you, where is that happy medium? Because we're going to get to EnFish here as one of the cases that I think that you've got to focus on and take an important teaching from, because if you don't describe, at least to some extent, what is new and different,
Yeah.
then you can't ever overcome the no patent for use syndrome under 101. But you also have to be mindful of the good deed goes unpunished. I mean, you say too
Right.
much and it's worthless. I mean, where's that happy medium for you as somebody who still prosecutes but who also litigates?
I gotta say that, it depends. The quintessential lawyer answer. It really is a focus, and I think what you also have to consider is, um, perhaps you build a family of patents. Really, and maybe that's the answer. I think as they keep changing the guidelines, so to speak, our strategies change on what will be effective portfolio building blocks going forward. And so I think sometimes you like, all right, well, maybe I will narrowly focus this first application as this example, and then the claims to this precise example where we're using this hardware and this software, and but maybe the second one in the family or concurrent in the family, or a little bit broader, and we give some other examples of other software that might work or other hardware that might work. But I mean, the bottom line is you do have to really drill down and talk about the novel aspect, what makes this so great in your specification, because the examiner has to look for it, and a judge is going to look for it.
Right. And that's, we're going to hit on that in a couple more slides here, but you know, that's the frustrating thing. You read a lot of these applications and you get to the end and it's like, I, assuming I really understand what they've done, I'm not sure what they think is new. You know, and that can't be the way you write applications anymore. And it is frustrating. And I get you don't want to say too much, but I also like hear you when you say you got to have a strategy to have different applications. Because I've been saying that for a long time. And the way I've always said it is, look, I got the message, I think, very early on, earlier than some, that you know these method claims in this area are just going to contaminate, at least in my opinion. Maybe I'll get your opinion on this. In my opinion, method claims contaminate these applications in the software space. You know, we in Alice, they took the method claim and then they said, well, in the system claim, we know the system claim is supposed to be covering the same as the method claim, so ditto for the system claim. And I just didn't know how is a system claim abstract, you know, and that just, it bothers me. And I do think you need to have different claiming strategies. And I think you want to sequester these from one another, almost like they have the coronavirus, right? You know, you want to keep them away from each other. Start with one specification and have one set of claims that go one way and another set of claims that go another way. Is that was what I was hearing you say, right?
Yes, yeah, I do that quite frequently, just to try and really think about alternative ways that you're, or what kind of competitors you might ultimately read this on. You know, you have to be nimble, so when it comes time to enforce, and it's harder to escape 3 patents than it is 1. Unless
Right.
you have a bazillion claims, and I don't recommend that. I mean, that's a strategy I know people employ where they have hundreds of claims in one application. That's one I just find really cost prohibitive for a number of clients. But that's another effective tool if you have the funds for it. I think it's more economical to prosecute too.
Yeah. Yeah. It's I mean, there's a lot of different ways to do it, I suppose. And I mean, I like, because most, not most, you probably say most clients are going to want a portfolio anyway, and having different claiming strategies and different patents, I think, is probably one of the most effective tools that you can have. Oh, and the one thing that came up there, I was losing my train of thought there for a second, but I don't have a slide on this, so let's mention this here. I almost added it, but I thought it might take us off on a tangent. But you mentioned making sure that you're having people who are actually infringing. With the indirect infringement, or the divided infringement, I guess is probably the better way to say it. That's a real problem, and particularly a problem with methods where one party can be doing one thing and another party can be doing another thing, and there is nobody actually infringing. And one of the ways that you can get around that is by actually having the more concrete system claims, and they're more focused. They're focused on smaller pieces that at least one party has to be doing all of this. And
Right.
you know that requires more nuanced claiming, and it probably requires more claim sets and maybe more patents. Not necessarily more claims, though, I suppose.
No, and I probably have made a conscious decision in the past, I don't know, decade or so that um, I really try and limit my initial claim sets to the 20 that we get. In
Yeah,
part because you're just going to get election restriction requirements, and you're paying for claims that you're not going to get examined in that application anyway. So I'd rather divert that extra money into a second application for more, economical patent portfolio building.
right, right. Okay, so let's go. And this is uh, this comes out in the October 2019 update. Now, I've heard a number of people talk about this and talk about it when I was out and about over the last few weeks. I talked to at a couple bar groups, and there's this idea that the October 2019 update changed the January 2019 revised guidance, and that is not correct. If you look at the 2019 update, what it says specifically there is that all personnel are specifically instructed to continue to follow the revised patent eligibility guidance, or as the Patent Office refers to it as PEG, from 2019, January 2019, which that does supersede MPEP 2106. And the October 2019 update deals with practice and procedure for patent examiners and includes some very detailed examples. So you probably want to take a look at that. So this flowchart is in flowchart speak what was in words on the previous diagram there, on the previous slide rather. I picked out some stuff I wanted to talk about because I think in this space, in one of the real problems continues to be, and I guess, and I hate this term, mental process. I mean, I think, and Dave, I would like to get you to weigh in on this too, because I think a lot of the problems that we have with quote unquote software patents, which is a problem in and of itself, calling these software patents, because software is that which calculates your calories on your phone when you're trying to lose weight, like I am always trying to do. And it also is what IBM's Watson is, you know, the next generation Star Trek computer. But mental processes, something that is clearly not a mental process can be called a mental process. And for the life of me, we're straining the English language here, but there is a problem. What they're trying to do is prevent very simplistic things from being patented. Do you have any general thoughts on that, Kristen and Dave, before we jump into this set of slides?
I'll just say, you know, I do agree with you. Like there are some examples that they've given of mental processes, and I'm like, well, I don't know if we've got somebody who is just hyper intelligent who can run multiple calculations in their head.
Yeah.
It does strain reality at times about what truly is a mental process. I guess I could say yes, if I had hours and hours or weeks, I could probably calculate something using the appropriate mathematical formulas to arrive at a result. But you know, the reality is that we don't do that.
No. So the claims do not recite a mental process when they deal with absolute positioning for GPS receiver. Well, thank God, right? Or detecting suspicious activity by networks, or decrypting encryption, or you know, half tone image for digital image. But they do when you're collecting information, analyzing, and displaying. How is that a mental process? Displaying, comparing BRCA sequences, and identifying headshot. Okay, that last one that's just silly. That was, they tried to get like In Ray Brown trying to get like a haircut patented. But the first two, you know, like I think what's going on here is they're trying to say it's a mental process if what you're doing is using a computer to do something simplistic that has already always been done in the real world. And the next slide kind of says that same thing here. I mean, claims can recite a mental process even if they are being claimed and performed on a computer. Well, that statement's logically impossible. I mean, it can't be a mental process if it's being performed on a computer. So there's got to be some deeper thing going on here. And I think the deeper thing that's going on here is they're trying to get us to stop applying for patents on this morning in a meeting somebody used the example like an app to ask somebody to marry you, like a marriage app, you know? Well, people have been asking others to marry them forever. An app is something that exists the fact that you put those two things together doesn't suddenly make it patentable, because there has never been an app to ask somebody to marry you, you know? And what they're trying to do is they're trying to pound this into a 101 peg into a square hole. You kind of hopefully get what I'm meaning. Round peg into a square hole, because they don't want it to get to 102. They don't want it to get to 103. And that's largely because of litigation issues, and they don't want to have to lose the ability to deal with these issues on a motion to dismiss. But then that affects the way the patent office has to deal with it, because then it becomes a 101 issue for examination. Kristen.
Yeah, well, I think in part it's, you know, I think you're right. They're trying to kick out certain uh, so-called inventions before the examiners have to undertake an arduous search for some document that shows what was in the prior art. So like you said, you know, trying to find a document about marriage proposals, like, yes, you can find some, but in the specific way that the app is asking, I don't know. It might be difficult, even though, you know, in your heart of hearts, you know, people have been doing this forever.
Right.
But trying to prove it is a whole other thing. So I think you're right. It's like, okay, we'll just go ahead and put this other, we have this other tool, we have this other statute 101 that we can now say, hey, look, this this isn't really anything new, and I looked at your spec and you really haven't given me anything to point to. So I just don't think it's patentable under 101.
That's right. So they're saying you don't have to go down the 102, 103 path and suffer the indignity of trying to find prior art for this app, you know. And it's frustrating, but that's the world that we live in. So all right. I mean, let's get into some of the claims and see what all of this means when it starts to play out. One of the examples that the Patent Office used in the October 2019 set of examples is an example, a claim for a controller. And they had about 2, maybe 3 pages worth of text describing this controller so you would understand what the invention is. For the first 2 claims here, and I picked this example specifically because you don't really need to understand the technology in order to understand why claim 1 and claim 2 are ineligible and ineligible. You do need to understand a little bit about the technology for claim 3. I have that little bit on the next slide. So under claim 1, which the Patent Office concludes is ineligible, you have a controller for an injection molding apparatus having a mold defining a cavity for receiving uncured polyurethane that is heated to form a molded article during a cycle of operation of the apparatus. The controller configured to A, repeatedly obtain measurements, B, calculate the extent of the curing completion using the Arrhenius equation, and C, determine the extent that the polyurethane is cured. So all they're doing is measuring, calculating, and determining. Okay, now that looks and feels an awful lot like Bilski, right? I mean,
Yeah.
everything there could be the types of thought processes, the mental processes, right? The things that could go on in one's mind if your mind could operate fast enough. There's nothing tangible necessarily. Now there is some stuff, obviously it could be tangible, but there's not that real concrete tie to an innovation. Okay. Now look, so that's ineligible. Now look at number 2, where it's the controller of claim 1, which is further configured to D, send control signals to the injection molded apparatus once the polyurethane has reached the target percentage. The control signals instructing the apparatus to open the mold and eject the molded polyurethane. Now, the Patent Office, the example did not, as I went through and I was looking at these to try and figure out on my own, which ones were eligible, and more so why, because they tell you right up front, this one's eligible, this one's not eligible. But why? I was reading the explanation for 2, waiting for the explanation to say, because this is an application. Because if you go back here, if you are claiming something that recites a judicial exception, which claim 1 did, but you add a practical application, then it's fine. Then it's patent eligible. And I think element D here certainly adds a practical application. That's what they're looking for. It's the production. It's the production cycle. Kristen, thoughts on this?
Yeah, no, I do agree. It looks like it's improving by, I guess, it's really automating the opening of the mold, or before you would look at the temperature and determine, oh, well, it should be cured by now. Now I will open the mold.
Yeah.
So they're using the computer from that standpoint. It's actually, it might have a 103 problem because you're just automating. But
Right. It depends
look,
upon who the judge is, probably, right?
right. But it doesn't say, like, when you look at the claim, you're saying, okay, it's sending control signals. Okay, how?
Yeah. And I mean, these are things that obviously matter, but and I can't say that I recall whether the explanation explained how it was doing that or so forth, but I do think that if you look at these 2 claims, I think it's fairly easy to see why claim 1 would be in what I would refer to as sort of a naked or dangling claim in need of some level of concrete application to tie it all together. And then 2 kind of adds that concrete application to it. Now, whether or not this winds up at the end of the day being enough to satisfy an examiner, enough based on the specification that you wrote, or enough to overcome 102 or 103, those are different questions for a different program. But that should be enough to get you over 101. I mean, Dave, what are your thoughts as a former examiner here when you're looking at this?
Yeah, I mean, I agree. I looking at this factual scenario, it reminds me a lot of Diamond v. Deere, where they actually held that the claimed invention was patent eligible, and just because there was a mere mathematical formula in the claim, whereas you could say here, just because there's a computer involved, in my opinion, doesn't necessarily mean that it's patent ineligible. It's doing something. It's a useful process. I mean, when you go back to the 101 statutory language, it's a useful process, and that's where I struggle with a lot of this. I feel like the courts have kind of muddied the water to a certain degree, where now they're looking at statements in the spec. Is there something that transforms the claims beyond just patent ineligible subject matter? And so you start looking at the spec to see if there's useful beneficial results, unexpected results, some of the Graham secondary factors. I mean, that seems like we should be relying on 103 for those sort of arguments and not muddying the waters under 101. But it's funny though. Earlier you had mentioned, you made a comment about, you read through the application, you're wondering what in the world's patentable here, and I can tell you I've had some of those moments as well as an examiner. But one thing I think is funny, and not to get us too far off topic, but back in the day, many years ago, it was not uncommon to have patents where they had a very detailed background, where they were going over the prior art with a fine-tooth comb and calling out the deficiencies. And then the pendulum kind of swung the other way, where now you don't want to say anything in the background because there's a tendency, or at least an understanding, that the examiners may latch onto that as applicant admitted prior art. But I think now with 101, it's almost the pendulum swinging back to the middle, perhaps, where it's to a certain degree, just kind of like what Kristen said earlier, you don't want to put too much in your spec, because everything you say may come back to haunt you in litigation. But at the same time too, you want to put enough in there to where you're speaking to the benefits, to where maybe the court will latch onto that as what carries it over into transforming the claims into patent eligible, or to be patent eligible. So
Right. So now this is where the webinar has a chance to go in a number of different directions, because there's a lot on the table here at the moment potentially. Because I said that we wanted to talk about Berkheimer, and Dave, you brought up newness, novelty, KSR. And when you're talking about Berkheimer, let me see if I can find and push the Berkheimer slide really quickly. Here we go. Berkheimer, recall, this talks about whether there's a genuine issue of material fact. And if there is, then the claim cannot be on summary judgment determined to be patent ineligible because there's a fact. Now, then that gets used to then create the so-called Berkheimer guidance, which we know forces the examiner to use one of 4 different criteria, which if you force the examiner to file an affidavit, then winds up becoming really one of 3. There has to be an express statement in the spec, court decisions, or a cited publication in order for an examiner to say that something is well-known, routine, or conventional. They can't just make that conclusion. So how do you do that? How do you make sure that you weave that into the claim? And why is that important? Well, one of the cases that the Supreme Court recently refused to accept cert on was Berkheimer. They didn't take Athena Diagnostics, which I thought was bad. They did not take the Vanda, which was good because that was pro-patent eligibility. They also did not take Berkheimer, which was good because that is a pro-patent case as well, because it gives some hope. So we know that Berkheimer, at least now for the foreseeable future, is going to be the law. So how do we as drafters weave this in? Well, I think it's critical, one, that you have to have some discussion in the specification of what is the new, which is required, or not required, but is really going to put you in good stead for ENFISH. Remember, in ENFISH, they wanted to know what the improvement was. What does the patent teach the benefits are in comparison to the prior art? And if you have that, and then you can put that into the claim and make that into a factual issue, then you can have the ENFISH statement from your specification with the hook to that in the claim. And by hook, I mean there's got to be something in the claim that references what you've said in the specification when you're talking about the difference between the prior art. So if you say that it is it's more efficient at storing energy, then you've got to have something in the claim that references the storing of energy. Okay, well,
Right.
then
Otherwise, you're in a two-way media versus Comcast cable situation, where they
right,
basically said it's great. It's great if you put in the spec, but it's not in the claims.
but it's not in the claim, right? So you have to have something in the claim. So if it's in the claim and you made that comparison, however brief it may be, however general it may be, but you've explained that it's superior to what's been done previously, now you're gotten your ENFISH qualifier, and now you should have some kind of, hopefully, Berkheimer benefit of the doubt in terms of it being a factual matter. Now, what I will say is this morning I laid this on Judge Michelle. So at a meeting I was at this morning, and Kristen is laughing because I told her how that went. And Judge Michelle looked at me and he gave me that one of those looks, and he said something to the effect, well, in theory, and he was not persuaded. And it's not that he's not persuaded, because he's persuaded, he gets it. He would agree with that. But his point is, not every judge is going to see it that way. And he's unfortunately probably correct. But what are we going to do? I looked at him, I said, well, what am I supposed to do? What am I supposed to tell people? I got to tell them something. We got to try something. So what I'm telling you to try and do is follow ENFISH. Put something in there about the improvement. Then make sure you have that thing that is the difference, that is improved in the claim, so that you can get the benefit of the doubt from the Berkheimer material fact, issue of material fact. Now, Kristen, where did I go wrong there, if at all?
No, I don't think you did. And like I always, when I teach new prosecutors, because I do a lot of work too in the mechanical space, and where everything is obvious to the examiners. And we have to do kind of the sales job, is what I call it, in the background. There's something you're trying to make better, or you're doing something in a very unconventional manner. In both of those, whether it's better or different, or just unconventional and contrary to what typical practice is, I think you need to put some reference in there, in your specification, because even if I know we're talking about 101, but you're also going to need it for the 103.
Well, absolutely. I mean, I think now the other thing here too, and going back to where were we when I went, okay, so here's the claims from our controller. So claim 3 was another example of something that was eligible that the Patent Office used in October 2019. And it reads very simply: a system comprising controller of claim 1 connected to a means for temperature measuring that repeatedly measures the temperature of the mold. Okay, now I understand how fraught it is to use means claims when you're dealing with software. So don't forget the NOAA systems cases that say that if you're going to use means claims with software, 100% of the algorithm needs to be present. Okay, so yeah, you're going to have an enormously robust disclosure. Okay, we all know that. But means claims can help you overcome the 101 hurdle. Now, this is also from the explanation of the technology. The applicant discloses a means for temperature measuring, which is described in the application as better long-term performance, faster response, and durability than other known thermocouples. Okay, so it's an improvement. Okay, so the means that were disclosed were an improvement over what was known in the prior art. So that's why if you come back here, this means for temperature measuring, that in and of itself is enough to overcome 101, because when you look at EnFish, that gets you past, because it's that innovation. It's the innovation that's the 2B. That's the 2B. So yeah, you were claiming something that was abstract, but then you had an innovation there that's present. And the innovation, how do we know it was an innovation? Well, because you told us in the spec.
Right.
And it doesn't need to be a whole lot more. You look at these cases that do this, Kristen, and it doesn't have to be a whole lot more than a line or two, right?
Right.
Yeah, this case reminds me a lot of that visual memory versus NVIDIA, where basically, it's a computer memory system with a larger cache than previous memory systems. And they basically said, we're going to hang our hat on the spec because you said that, your computer-related invention is improved over conventional ones. It has an enhanced performance, improved efficiency, and reduced costs. And that was basically like those secondary gram factors that we were referring to earlier. That was enough for the court to hang their hat on and say, yeah, it's patent eligible.
Yeah.
Oh,
All
and
right.
one thing I wanted
So,
to add too, if you don't mind, real quick, is Kristen had mentioned earlier about in the courses, the patent law course that she teaches, basically speaking to trying to overcome deficiency of the prior art. I would also say, like, if you look at the rapid litigation management versus sales direct case, that was a situation where they actually included prior art teaching away examples of common sense would say that you wouldn't subject cells to multiple freeze thaw cycles, but based on prior art knowledge that damages the cells. And that was a perfect case where they ended up finding that there was patent eligible subject matter there because the prior art taught away from it. So I would say not just prior art deficiencies, but also situations where the prior art teaches away from your claimed invention. Maybe it's worthwhile to put that in your spec as well.
yeah. So the other two cases that, so I mentioned EnFish and how you can try and use that together with Berkheimer. The other one that you gotta know about in the software space, and everybody I'm sure does, is McRow. And it's because if you're gonna and this is the lip syncing case, and they claim rules in the claims. Here's the claim from the patent itself. So if you're going to have code relevant to what's going on, and you're going to try and use those rules and leverage those rules in the claims itself, and so this is a method claim, but it's a kind of method claim. It's not just a naked recipe where shake, stir, swallow. You're incorporating the rules and really explaining what's going on in the technology, or at least that's the type of claim this is trying to go at. Does it go as far in depth as some of these rules-based claiming does or can go? No. Was it enough? Yes. A lot of people probably say, and I've heard a lot of people say that it was barely enough. Well, it was enough. What I would point out is if you go and you look at the specification here, there are no, quote, first set of rules mentioned in the specification. There are all kinds of rules in the specification. So, but if you're going to use a term like first set of rules in the claims, there should be a first set of rules in your spec. So for God's sake, make sure your claims match up with your specification terminology,
Right.
and that's, something simple that, and we'll get to it in a minute. Dave will talk to you a little bit about Patent Optimizer, but that's one of the simple things that Patent Optimizer can do for you to make sure you're not going to make a careless mistake. And then in FinGen, and this is, you might think that, okay, this is sort of a one-off case because FinGen, and Judge Dyke wrote this decision, and it was patent eligible. And Judge Dyke said that, acknowledged that FinGen was the pioneer of this behavior-based virus scanning approach. And here's the claim. The claim is very short. It uses the term downloadable all over the place. Well, what is a downloadable? If you go to the FinGen spec like I did, this is just 3 paragraphs. The first one is there was 2 paragraphs in the background explaining the problem, and one paragraph explaining the problem with the downloadable. The virus scanning didn't scan what was attached as a downloadable prior to this. And then the first paragraph of the summary explains what they mean by downloadable. And then the whole specification uses the term downloadable over and over and over again. So it makes it really hard to read this claim as being super short and simple when the specification goes into example after example after example of what this means, how it's going to be used, how it's going to be compared, and what you're trying to do with it. And why is this important? It's important because virus scanning of the day was only scanning, wasn't scanning that which was attached to be downloaded. So it's important to do these things this way. So sometimes I think we read these cases, and if you don't go and you look at the specification or the claims in light of the specification, you don't understand just how important a holding the case really is and what you can really learn from it. So the FinGen case is extremely important. Use terms that you define in your specification in your claim, because that then provides that hook that I was referring to that you can then tie with your Berkheimer strategy, as we were just discussing before together with EnFish. Because now, if you, and I think that this FinGen case came out, was this right before Berkheimer? Let's see, this was Berkheimer's an 881 decision. Yeah, so FinGen came out before Berkheimer, but after Berkheimer, downloadable, as this is then described in the specification as being an advance, and this is better than the prior art. Well, then this then becomes a question of fact. So you can use this claiming techniques to your advantage as long as you have some specificity. And it doesn't require a ton of specificity. It just requires a little bit of thoughtful specificity, both in the claims and the specification. So I'm not saying, and I know Kristen's not saying, and Kristen, I'd like you to confirm this. We're not saying do the old-fashioned page after page of background.
Oh
We're
God, no.
talking right. We're talking about some real thoughtful, a line here or a line there, right?
Yeah, I always like to look at the background as like if I've got to describe it to a layperson what it is that I'm focused on, I that's what I use the background. It's just enough to educate them about what I'm trying to do, but not too much to get me in trouble.
Yeah, right, right. All right. So now this webinar has been brought to you by LexisNexis and Patent Optimizer. And Patent Optimizer can solve a lot of these kinds of problems with the deficiency. Certainly the problem that we were just talking about with the McCrow case, where you're using terms in the claims which are not, you wind up using in the specification. Dave, can you tell us a little bit about how Patent Optimizer can help save us from our own drafting errors?
Yeah, certainly. Thanks, Gina. I appreciate the opportunity. Yeah, there's a lot of different ways. So we have some phenomenal features within the tool that can do the basics like we were just talking about, making sure that you have sufficient written description within your spec to support those claim elements. You can also leverage the tool during prosecution. So when you're adding claim limitations to overcome a prior art reference, you can leverage the tool to make sure that you're not introducing prohibited new matter. But there's a lot of other things that you can use with the tool, like, for example, if you practice in the mechanical and or electrical arts, one of the things that's phenomenal with the tool is our check parts feature that essentially will identify situations where you may have the same, part name being identified by different part numbers. It could also be the same number identifying different names, so we'll identify those ambiguities and let you correct those in real time. Also, situations where you just want to quickly navigate from a part number and name into the drawings and back to the spec. Also, situations where maybe you refer to a figure number, in your spec, but there's no corresponding drawing, and vice versa. And then one of the really nice features, if you know you're going, maybe filing in the EPO or other patent offices where they actually require you to have the part number within the abstract and or the claims, the tool can auto insert those numbers in for you through a click of a button, basically. So other things that the tool can do is obviously identify patent profanity. So we mentioned earlier, claim terminology that might render the claims vague and indefinite, functional, impacting claim breadth and scope, invoking public relations concerns or considered offensive. And one really cool feature when it comes to functional claiming, which you touched on earlier, is our ability to leverage our thesaurus. So if you're drafting an application, you've got means for doing this or means for doing that. You can actually look into the entire U.S., WIPO, European, and Canadian patent corpus to identify structural variants that have been used by other patent practitioners as well as lexicographers for potential inclusion within your own application. So we'll identify structural variants that have been used in those patent corpuses for accomplishing that claim functional language. And of course, at that point, if you want to include that within your specification for satisfying 112 F or 112.6 paragraph, obviously, that would bode well, especially in PGR post-grant review type situations. And then, I won't go through all these, obviously. If you're interested in seeing a demo, I'm happy to provide you with a demo. But last but not least, on the next page, we talk about the benefits of leveraging a tool like Patent Optimizer. And so, there's a lot of pitfalls that you can fall into, not just during prosecution, but also post-grant challenges. And, the whole idea is to be able to, speed up your efficiency without taking a hit to quality. And so, obviously there's a lot of other pitfalls associated with failing to have good quality. Obviously, you can see them here on the screen. I won't go to all those, but there's, at the end of the day, there's a lot of investment and time and as well as money from legal fees, government filing fees, and if you're not leveraging a tool like Patent Optimizer to catch those, you're really missing the boat. I mean, the cost is very reasonable. Roughly an hour of billable time, and it's going to speed up your efficiency and help you be more profitable at the end of the day. So feel free to reach out if you're interested in learning more.
Okay, well, thanks, Dave. Now,
Sure.
Kristen, I'll give you an opportunity to wrap up. What is your final thought for people to take away?
Oh, I think one of the things that you really have to focus on when you've got a claim, that you're interested in pursuing, is to think back of, okay, go back and look at what the examiner is going to evaluate under a 101 and make sure you have that you meet that step 1 or step 2. Have a plan with your claim set to be ready for that 101 rejection.
Mm-hmm. Yeah, that's certainly very, very important. One thing that we didn't really get to, but I'll try and get to quickly in my last thought here is to pick up on something that, you know, Dave mentioned, and we've been kicking around here with the language issue, adapted to versus configured to. And we have a slide for each of these here. Now, adapted to, it's not to say that adapted to is never going to be possibly interpreted as means plus function, but configured to, as far as I can tell, the only time it is ever used, that I've ever seen it used, and certainly the only time it's used in the MPEP, is with respect to being interpreted as invoking means plus function. So you want to be careful with those two terms. So if you want to stay away from the Williamson stuff, and in the software area, I think that's very important to do. Or if you're going to go into the means plus function area, you want to go eyes wide open and know that you're doing that. Be very careful, and I would stay away from configured to language. Now, there's no bright line rules, and I'm not saying if you did this, oh my God, don't have a panic or anything like that. But, you know, adapted to is probably more structural than configured to. So I'll leave you with that little tidbit as my parting thought for today. And thank you all for joining us, and thank Kristen and Dave and LexisNexis IP for sponsoring this. And hopefully we'll see you on another webinar here soon. So you guys have a good rest of the afternoon, and we'll talk to you soon.